Good morning, everyone. The Senate Judiciary Committee will come to order. And our first order of business is we have a new committee member to welcome to Senate Judiciary. We have Senator Mark Steffen. If you want to say hello, Senator, and where your district is, and introduce yourself.
Thank you, Madam Chair. It's a pleasure to be here. I'm honored. Yes, Senator Mark Steffen, Senate District 34, which is Reno and the northern half of Kingman until 2024, when it'll be all of Kingman County and Barber. So, yeah, thrilled to be here. I hope to not weigh the committee down.
I don't think that'll be a problem. Thank you, Senator. Appreciate that. First, then, we will start with, do we have any requests for bill introductions from anyone in the committee meeting room? Yes, Senator, go ahead and introduce yourself and welcome to committee.
Hi, thank you. Senator Clays. I'd like to introduce RS 0839. It authorizes the Attorney General to prosecute a criminal act or conspiracy that involves 2 or more counties.
Thank you. And the bill is so introduced. Thank you, Senator. Yes, Mr. Klump, please introduce yourself and welcome to committee.
Thanks, Madam Chair. Ed Klump, I'm here on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. We have 3 bills we'd like to request. The first one is 23 RS 0742. It has to do with the entire article in Chapter 19 on jails. It has not been updated since 1923, and it is in serious need of revision, and that's what that is about. That's 23 RS 0742. You want me to just go through the whole list?
Sure, that'd be great.
The second one is 23 RS 0743, and that has to do with the statute on interference with a law enforcement officer, and that one's 23 RS 0743. The third one is 23 RS 0744. This has to do with our hiring process and the background investigations. There's an existing statute giving us access to other agencies' background checks and information on applicants. And that has some gaps in it we need to fix, and that's what this bill is about. And again, that was 23 RS 0744, so we respectfully ask the committee to introduce those.
Thank you, and the bills will be so introduced. Are there any requests for bill introductions from committee members? From anyone else in the committee meeting room? Seeing none then. Our next order of business will be to open the hearing on Senate Bill 73, and we'll ask for a statement from the reviser, Mr. Thompson.
Thank you, Madam Chair, and good morning, committee. Jason Thompson, Office of Reviser of Statutes, first bill brief of the year, so here we go. You have it in front of you, hopefully, and I won't read it. It's typical. Senate Bill 73, as you can see from the short title, adds domestic violence or domestic battery and violation of a protection order to the crimes that a person can have the intent to commit when committing burglary or aggravated burglary. The statute that's amended here is KSA 21-5807. That's in the criminal code. It defines what burglary and aggravated burglary are. Current law that you can see there prohibits without authority entering into or remaining in a certain dwelling or building or conveyance with the intent to commit some crime therein. The bill is adding to those elements intending to commit domestic battery or violation of a protection order. And I noted in the bill brief, and I believe the Sentencing Commission's bed impact notes this as well, that this would add misdemeanor crimes of domestic battery and violation of protection order to the crimes you could have the intent to commit, because right now the statute only talks about felony offenses. And most of those domestic batteries and violation of protection order crimes are misdemeanors, not felonies. So that's the gap in the law that's proposed to be addressed here, and that's the policy issue that they're presenting for you. I'm happy to stand for questions.
Thank you. Committee, any questions for the revisor? Seeing none, then we will have our first proponent, Mr. Will Hurst, from the District Attorney's Office from the 10th Judicial District. That's where my district is, the Senate District. So welcome to committee. Please introduce yourself.
Good morning, Madam Chair, and good morning, committee members, and thank you very much for the opportunity to address you all this morning. I am an assistant district attorney in Johnson County, and I've been prosecuting in Johnson County since 2011 and in total since 2007. I'm speaking in support of this bill because I have stumbled across what I feel is a loophole that needs to be fixed in order to protect some of the most vulnerable members of our community. And what started this is last year, we had a case, and I mentioned this in my written testimony. I had a case where a man had battered his girlfriend and had a very serious criminal history, but managed to bond out. And one of his bond conditions was that he was not to have any contact at all with his victim. Stay away from her, stay away from her house, stay away from her residence. Well, about 2 months later, at 3 o'clock in the morning, that victim woke up in her own home with that offender standing over her bed, in what I can only imagine would be one of the most terrifying experiences that she's been through. And she called the police. The police came out and arrested him and talked to her, and she was obviously very visibly shaken about what happened. Well, we initially charged aggravated burglary, but as it turned out, there was a case from the Kansas Supreme Court, and I cite this in the written testimony. It's from 2019, that essentially said, hey, yes, you have the felony stalking here, but that felony stalking cannot be a basis for an aggravated burglary. And I won't get into all the details on that, but it's just not good enough. And so I was forced in a situation that I thought was very concerning, very dangerous, to dismiss that felony charge. And I wish I could tell you that that was the only situation where this has come up. It's not. I have another situation just like this. And I don't think it's appropriate, and I don't think it's the legislature's intent to have an individual who breaks into a home when there's a protection order, or when he goes in and he strikes a significant other, that the worst thing they face is a Class B misdemeanor, which, for the record, is actually a lesser crime than it would be stealing a Snickers at Quick Trip. So I believe this is something that will protect victims of domestic violence. As I said, some of the most vulnerable members of our community, and I would urge this committee to support it. So with that, if you have any questions, I'd love to answer those.
Thank you. And committee will go ahead and reserve questions till after we've heard all the conferees. So thank you very much, Mr. Hurst. And next we will hear from Aaron Breitenbach, Deputy District Attorney for the Wichita area. Which judicial district is that? Which number?
18th Judicial
The
District.
18th. There you go. Thank you, Mr. Breitenbach, on WebEx. So please introduce yourself and welcome to committee.
Thank you, Madam Chair, and thank you to the committee for allowing me to appear remotely. I'm obviously happy that Will was able to be there in person. I just wanted to join here on behalf of the Central County District Attorney's Office and the KCDA, the prosecutors group, to again add our voice to the need for this. Will spoke to it very well, so I don't want to belabor the need, other than to say this really is an opportunity to I think, increase confidence in the court system, candidly, and in the justice system, because our victims come to us expecting protection. When they take that bold step of stepping forward to identify someone who is terrorizing them, they expect us to then have their back. so that they can feel safe to make those accusations and then be safe as that criminal justice system works through whatever the outcome may be. But when our protective orders really don't have much teeth, it makes it harder for them to feel safe coming forward and decreases the likelihood that they'll do it until something even worse happens. And really the purpose, we hope, in all criminal law is to address problems, to get offenders help and prevent future crime, as opposed to waiting until the worst possible thing happens and then trying to react when already too much harm has been done. So we see this as an extension of the laws that already exist and just trying to fill the gaps, as Mr. Hurst spoke to quite well. So again, one detriment of appearing remotely is I don't have the benefit of seeing any of the written opponent testimony, so I'm not sure what all concerns they have. I did see the fiscal note, and I recognize that matters. But again, I'm not sure that there's a better investment we can make than in making sure that the victims who have the courage to report crime, particularly in the context of stalking, protections from abuse, domestic situations, I don't think there's a better investment we can make than protecting those victims and making sure that their voice is heard throughout the court process. Thank you very much.
Thank you, Mr. Breitenbach. Committee, you will see there is a fiscal note for Senate Bill 73 in your committee documents, and the impact assessment in your committee documents as well. And then we will also hear now from Mr. Ed Klump. If you'll want to introduce yourself, and welcome to committee.
Thank you, Madam Chair, committee members. Ed Klump, Kansas Association of Chiefs of Police, Kansas Sheriffs, Kansas Peace Officers Associations. We have an interest in this bill for several reasons. One, as you know, domestic violence cases are one of the most hazardous calls that our officers go on. But we also like to stand up for the victims in all crimes. And this is a particular one that is still a very serious crime. We face a lot of them. Way too much domestic violence still occurs. And we think this is a good bill that will help addressing that. Continues to be a major crime of violence. Protection order violations are way too often a part of these cases. We often run into people violating those protection orders in further violence that occurs. So in this case, we're talking about the crime of burglary. And I thought I'd just real quickly go over what the elements of those crimes are, and so you fully understand how this would apply. So in burglary, there's basically three elements to that crime. One is a person has to enter into or remain in one of those listed structures or conveyances. And the second one is that it has to be one of those spaces listed there. And the third is then what's their intent when they went in or when they remained. And that's what this bill is about, is talking about the intent. Felonies are already covered. So if you have a case of a felony domestic violence, this doesn't change what happens there. But these are the misdemeanor ones. And this is where we start seeing the level of aggression and the level of violence grow at these misdemeanor levels. And what this bill addresses is when those people unlawfully enter into a place to commit a domestic battery or in violation of those protection orders. That is a huge step beyond somebody gets angry and batters their spouse. This is a covert act to get into a place to commit this crime. And this is a strong sign of an escalation of this offender's aggressiveness to hurt the victim. And it's also a good indicator we have found in future levels of the violence that they're going to inflict. And so we think this is a very good bill. It's going to maybe stop some of these before we get into those felony assaults where we have grievous injuries to the victims, and we strongly support the bill. And I'll stand for questions when it's appropriate.
Thank you. Committee, that is the list of proponents that we have, but I'll ask, are there any other proponents in the committee meeting room or on WebEx for Senate Bill 73? Seeing none, then we will open it up for any questions. And I want to first comment and say thank you to those who have brought Senate Bill 73 forward and to address this situation, kind of a gap in the law, if you will. And it looks like it's needed. So, and it could be a good fix, but we will see. So, committee, any questions? Seeing none, then we will then ask for, are there any neutral conferees in the committee meeting room or on WebEx? Seeing or hearing none, are there any opponents to Senate Bill 73 in the committee meeting room or on WebEx? Seeing and hearing none, then we also have written testimony in your committee documents from Stephen Howe, District Attorney for the 10th Judicial District, as well as Mr. Klump's written testimony and Mr. Breitenbach's testimony as well. And with that, then, we will close the hearing on Senate Bill 73. Thank you, everyone. And our next order of business is to hear from Heather Cessna, the Executive Director, Kansas State Board of Indigence Defense Services, regarding the criminal attorney shortages that some of our appointee in the confirmation hearings have been discussing. So please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee, for having me today. My name is Heather Cessna, and I'm not quite ready to put that up yet. So I gotta add this. My name is Heather Cessna, and I'm the Executive Director of the Kansas State Board of Indigent Defense Services. And first off, I wanted to say a quick thank you to the committee members for last week spending the time going through our board member hearings. I know that is a commitment of time and effort and resources, and obviously our functioning board, having current members on our board, is an important part of that process for us as it is for you. So thank you very much for holding those hearings and passing those two candidates out favorably. The reason that I'm here today is because of some of the questions that did come up during those hearings last week that I wanted to address. So with that, and you can go ahead and put my thing up. Thank you. With that, I wanted to address the questions that arose about the crisis with lack of attorneys in Kansas. I know some of you have heard the presentations from the Judiciary about the lack of counsel overall in Kansas. I think they estimate that we have about 25% of the attorneys that we need in the state right now. Obviously, there is a far smaller portion of people who do criminal law, and particularly who do criminal defense. So when there's an attorney shortage in Kansas, it is particularly problematic for us with the Board of Indigent Defense Services. And so I wanted to spend a little bit of time talking about sort of where we do have resources and why there are some shortages, so that I can hopefully answer some of your questions. Obviously, we do have a constitutional right under the Sixth Amendment to have representation for anybody who's charged with adult felony crimes. It is up to the state to provide that under Gideon versus Wainwright, Supreme Court case from 1963. And since 1982, we've done that through the Board of Indigent Defense Services. We have essentially two sides to our system, and that is our public defender offices, who are direct employees of our board, and our private assigned appointed counsel that are private attorneys that participate in our panels throughout the state. The volume here is what's important. 85% of all adult felony criminal cases in Kansas require appointed counsel, and BIDS provides all of those, either through our public defender's offices or through paying for our private appointed counsel. That's about 25,000 cases a year. Last year it was 24,609. Sometimes that goes up as high as 30,000 depending on any given year. So and you'll see that breakdown on here of 36% of those cases are handled by our public defender's offices. That is in part because our public defender's offices are not in every community. We have public defender's offices, and I'll go on to my next slide here. This kind of shows our organizational structure. But we have public defender's offices trial level offices in Olathe, Wichita, Topeka, Chanute, Independence, Hutchinson, Garden City, Junction City, and Salina. We have an appellate office in Topeka that handles cases from around the state. And then we have 5 capital offices that are situated between Wichita and Topeka that handle everything from trial level death penalty cases all the way up through capital habeas. And then our administrative office is here in Topeka. So obviously that doesn't cover the full portion of the state. I did put in a graph here so you can kind of see the list of counties that are covered by our public defender's offices, the list of counties that are covered by our contract counsel. Those are part of our assigned counsel program. And then every county is supposed to have a panel of attorneys that handles appointed cases, even if we have a contractor or a public defender in that area. However, obviously there are large swaths of the state, particularly in our more rural areas, where we have people who serve on multiple panels and cover multiple counties. So there may be a handful of attorneys that are covering 10 of those panels. So it's a little bit of a misnomer to think of that as every county has a lot of coverage, because there may not be a lot of coverage in every county. I did also want to provide you kind of a show of where our assigned counsel cases are and give you a little bit of an explanation as you're looking at this. And I'll use Reno County and Harvey County as an example, since we have a new senator here today from Reno. This is the number of assigned counsel cases that are handled by our panel attorneys or our contractors. It is not the number of cases that are handled by our public defender's offices. So for instance, if you look at Reno and Harvey County, it looks like there's more cases in Harvey County, but that's because there's a public defender's office in Reno that handles, on top of the 337 cases that the panel attorneys handled, the public defender's office handled about 760 cases on top of that. So there's actually more total cases in Reno County there, but this gives you an example of where the cases are located and where we're going to have shortages. Because as you can look in that like northwestern part of the state on here, I mean, there's a significant number of felony cases that are coming out of areas of the state where we just simply do not have a lot of counsel. And that is kind of one of the problems. Our shortages of counsel really are twofold, and understanding the volume of cases that we're talking about and the number of cases that we're trying to cover with our agency is important for the rest of the context here. We don't have enough qualified, experienced criminal defense counsel to meet the volume of cases that are being charged by local prosecutors' offices. There is several consequences of that. Our lack of sufficient staffing in our public defender's offices is part of the problem. We both were suffering over the last 5 years and more from high turnover rates, which have recently come down as a result of a pay scale increase that we were able to implement with the support of the legislature and the governor's office this past July. But those gains have been relatively recent. The extent of the turnover that we had over the last 5 years is that we do have a large number of very inexperienced public defenders who are excited to do the job, but they also just don't yet have the experience to handle the high caseloads and the higher level cases that a more experienced attorney does. And it takes time and training to build that up. And so that historic turnover rates have been particularly problematic for us. When I gave you some facts here so that you can kind of see what some of the consequences of this are, we have about 8 out of 11 of our trial offices have exceeded our national caseload standards, which says that you're not supposed to have more than 150 felonies per attorney per year. And out of the ones that did not exceed that, several of them only were able to stay below those national standards by temporarily refusing cases for almost or over 50% of the year. And so refusing cases, not being able to handle the caseloads at that volume really has a huge impact, because those cases have to go somewhere. They end up with our assigned counsel panels when we can't keep them in our public defender's offices. The other part of our problem is that we do have a large number of counties, both rural and urban, where we just don't have enough panel attorneys on our panels. In 2022, we ended up spending a significant amount of time either trying to help the counties listed here, including Crawford, Labette, Cherokee, Johnson, Douglas, Shawnee, Sedgwick, Geary, Riley, and Saline counties, among others, to try to supplement their assigned counsel panels by asking our assigned counsel from other areas to drive long distances in order to cover cases. In some cases, we're asking attorneys from the Kansas City area, where there's a heavier concentration of attorneys, to drive as far as 2 hours to Pittsburgh, or 2 hours out to, or an hour and a half out to Junction City to cover cases, because we have shortages of counsel in those local areas. So that kind of gives you a sense for the volume of the problem that we're talking about. There are several key factors that have contributed to this crisis, and I think it's important first to talk about what it is that we don't have control over when it comes to those factors, and what it is that we do. We don't have any control over the volume of cases that come into our criminal defense system. That is in part up to the policy choices that the legislature makes about what to criminalize and what to specifically make a felony. Our system only deals with adult felonies. The misdemeanors and juvenile cases are handled by individual counties. It's also up to the discretion of the prosecutors in each jurisdiction as to what incidents they're going to charge and how they're going to charge them, what levels they're going to charge those at, what kind of decisions they're going to make about moving cases through diversion, or having early plea deals in the process, things that contribute both to whether or not something ends up in our system and how quickly it moves through the system. Our clients have the decision about whether or not to plea, and obviously we have some influence over giving advice about that, but it is ultimately our client's decision and not ours as defense attorneys to be able to determine when or if to take a plea or when or if to go to trial. The things that we do have control over are our public defender's offices and our assigned counsel program. And those are the parts that I'm going to kind of focus on here to talk about how they've contributed to this crisis and how we can try to move forward. In 2022, we did lose 1 out of every 5 public defenders due to low pay. We had made 2 years worth of efforts to try to get a pay scale adjustment. We were able to get that pay scale adjustment at the end of last year, but not before some of that damage was done. That turnover rate is not going to be that way in fiscal year 2023 as a result of that pay adjustment, but obviously that kind of turnover rate still has a lasting impact. We also have an aging population of attorneys that are retiring and are not being replaced by insufficient numbers by new lawyers who are graduating from local law schools. Over the course of the last 10 to 15 years, there's been a significant reduction in the number of attorneys that are graduating and being admitted and graduating from our regional law schools, and they're just not replacing the number of attorneys who are retiring from practice. Additionally, those that are graduating are tending to stay in more urban areas like Wichita and Kansas City and not moving out to some of these more regional or more rural jurisdictions, which has made the shortage of attorneys in our rural areas particularly problematic. We also lack a sufficient number of full-time employee positions in order to deal with our caseloads. Even if we have every single one of our positions filled, based on national caseload standards, we still would need almost 262 additional employees, all the way from public defenders, investigators, legal assistants, support staff, in order to reasonably meet those national caseload standards. And so we still, even if we have every position filled, we are still going to need a significant amount of investment going forward in order to handle the caseloads that we currently have in the public defender's offices that we currently have in the places where they already are, and to be able to make an impact on the overload of cases that are going to our assigned counsel panels in those areas. We also don't have enough offices in the areas where we currently need assistance. We have a request this year, for instance, to add a public defender's office into several jurisdictions where they're underserved, either because they need additional assistance for the volume of cases or because of a lack of attorneys in those areas. And so one of the things that we've been looking at has been expanding those offices out because there is such a need. There's also been other factors that have contributed to this. Obviously, we've been through the COVID backlog. Some of our jurisdictions are moving through those backlogs of cases that kind of stalled out during the COVID court slowdowns faster than others. Some of those are still lingering. It was really every jurisdiction tended to handle those backlogs very differently. So there are definitely some jurisdictions that are still suffering from those backlogs. Additionally, we've gotten reports from our panel attorneys that the tooling of statutory speedy trial has had some effect on just not moving cases as quickly. That's one of the few deadlines that puts pressure on both sides to try to come to the table as opposed to just the defense. And so that has been one of the factors that's been indicated to us has stalled out some cases and kept things from moving. And if things are not moving, then they can't clear their cases to be able to take more cases. So those have all been sort of factors that have contributed to this. Again, our board over the course of the last 3 years has been working on this issue. The problem is that the solutions to this are not easy, and they're not entirely within our control. We obviously don't have control, like I said, about what the legislature chooses to criminalize or make a felony. We don't have a lot of control over prosecutor discretion. What we do have control over is whether or not we can retain our current employees in our public defender's offices. And so to that end, we've really focused on trying to deal with the overload of cases in our public defender's offices and our pay issues in order to try to maintain those employees. We can control whether or not we're asking for sufficient staffing for our caseloads. And so that's been a consistent conversation that we've been having with our budget committees over the last couple of years in order to both meet our current caseloads and to try to give some assistance to our overloaded panels. We can review other jurisdictions to see where there is needs. We've been through the process in several jurisdictions already of holding public hearings and having extensive board conversations and analysis of data to determine where we might need to consider expanding the public defender's offices to cover cases that can't be handled sufficiently locally. And, we can continue to advocate for better resources for our assigned counsel program so that we're bringing more attorneys onto our panels. 3 years ago, our panel attorneys were being paid $80 an hour, which was insufficient for many of them to be able to cover even just their basic overhead costs. And over the course of the last 3 years, we've been able to, with the assistance of the legislature and funding from the legislature and recommendations from the governor's office, been able to increase that hourly rate from $80 an hour to $100 an hour, and then from $100 to $120 an hour. That is still significantly below what it would cost to hire a private attorney at an hourly rate. But it has made a difference in being able to pull additional people onto our panel list that wouldn't serve otherwise because they just couldn't afford to essentially do pro bono for so many of those hours of those cases, because criminal cases, especially higher level ones, take a lot of hours to invest. And then we've continued to work with jurisdictions in order to find other ways that we can assist locally, either through local policy and procedure changes or through collaborations with efforts on the more local level of ways to kind of work through some of our backlog of cases, or to be able to find ways to provide counsel for unique situations. So it's been an ongoing process. Just so you have kind of a brief overview, in order to make those things happen, we have to consistently ask for a significant amount of budget enhancements in order to make that happen. So I gave some estimates here of what's in our budget request for this year, for fiscal year 2024, so that you can kind of see how those efforts at those general attempts to deal with the parts of the crisis that we've got control over have actually manifested themselves in specific budget requests. So I put that in your information packets as well. The bottom line is, we are continuing to work on these issues. We're continuing to make consistent requests. We're dealing with local jurisdictions. The real question is, are we going to be able to deal with this fast enough before we essentially get to a constitutional crisis if we're not there already? And that's the difficult part. Things don't move very quickly, as you can imagine, as far as trying to build back up the number of attorneys that we need in these jurisdictions. And in the meantime, we are very much struggling to try to connect the attorneys that we have with the cases that are out there. We spend a lot of time literally making phone calls, asking people if they will drive across the state to handle cases. We spend a lot of time looking at vouchers, trying to make sure that we're paying for things like windshield time when they do agree to do that sort of thing. And we are participating in some of these larger conversations like the Supreme Court's task force on rural representation issues, because they understand that, we're a significant portion of that, even though it's a larger criminal justice issue and a larger issue than just criminal law. And so we're continuing to have those conversations. But it is definitely difficult. And I am more than happy to answer any specific questions that you have about this issue, since I know that's something, as I said, that came up during our nominees' confirmation hearings earlier this past week. And I'm also happy to provide any additional information that you might need on this topic. Thank you.
Well, thank you very much for that very thorough presentation. And thank you for providing on one of the slides workable solutions. Oftentimes we're here and, we hear of problems, but it's nice to have a solution proposed as well for something for the legislature to consider and have conversations about. And you've mentioned that in the criminal context, there's a constitutional right to have an attorney appointed to represent you if you can't yourself afford one in certain criminal cases. And it's important in our system of justice and our legal system that we have vigorous representation on both sides of the verses in the criminal context as well as the civil context. So if our defense side of the judicial system, the legal system isn't working, what are your thoughts on what that means for Kansas?
I think we run a real risk for statewide constitutional litigation, and I don't say that lightly. Certainly there is a lot of that going on in other states for essentially the same reasons that we have here. It is, I don't mean to make it sound like I've got any insight that there's anything out there here, but certainly the delays in appointments of counsel, the lack of sufficient counsel to handle those sorts of caseloads is the kind of stuff that you see happening in places like Missouri and Oregon and Maine and other places where there's currently that sort of litigation happening. I do think that there is a global recognition amongst all of the participants in our criminal justice system that this is a problem that has been not created overnight, but is a long time in developing, and that it's not like you can just drop a bucket of money and solve it all in one swoop. That practically speaking, that would be very difficult to do. So I do think that continuing on our part, for those of us who have the ability to have an impact on this crisis, to continue sort of moving the ball forward, as it were, in significant and measurable ways, I think will help show that we're invested in trying to solve these issues, even though it is a long-term sort of solution that's going to have to build up over time.
Thank you. Committee, any questions for Ms. Cessna? Yes, Senator Baumgardner.
Thank you, Madam Chair, and thank you for your presentation today. You indicate on, I don't see the number of the page of the slide deck, but an aging population of attorneys that are retiring and not being replaced by a sufficient number of recent graduates. So we know from our 2 law schools in the state, as well as the law school that's there in Kansas City at UMKC, that they have not had a problem filling their slots for competitive admission. So what would draw a recent graduate to, even if we were to fund these positions, what would draw a recent graduate to even apply?
So that's a great question. One of the things that we've had to do in our agency is really start nationally recruiting, and we've tried to put an emphasis on nationally recruiting specifically for some of these more rural jurisdictions that are particularly difficult to hire for. The good news is that while regionally our law schools are not graduating large numbers of people, and probably don't have as much of an emphasis in public interest law as we would like to see. There are an awful lot of law schools, particularly as you get farther to the east, that have a larger population of graduates, that have a larger sort of interest or emphasis in those law schools on public interest law. And so what we've focused on is trying to catch those people as they're getting ready to go into their 3rd year of law school, to try to recruit them so that when they're making plans about where they're getting barred, that they're either taking their bar exams and transferring them to Kansas, or taking their bar exams in Kansas with the promise of a job afterwards. I think there are, one of the conversations that we've been having is with the Department of Commerce over some of the programs that they have for rural opportunity zones, for housing and student loan repayment and tax benefits and all kinds of things if somebody moves in from out of state to some of these areas. And a large number of where we need assistance is in these areas. But it really does take a national effort. I mean, we have been hiring people from Texas, from New Jersey, from Arkansas. We've hired some people from farther back east than that. But in order to bring in more people than what we have access to just regionally. So, I mean, we have had to designate a specific staff person to help us do that intensive and specific outreach for recruiting.
Follow up, if I might. So is there any type of summer associate positions available in bids for 1st, 2nd, and 3rd year law students?
Yes, the other thing that we have now is a more formal internship program, which we do pay for in accordance with the recent efforts from the executive branch to have paid internships throughout the state. We've been able to designate funds to be able to pay interns who are in their 1st or, between their 1st and 2nd year, or 2nd and 3rd year of summer to come out. Last year we had a group that was in Topeka and Wichita. Before that, it was kind of hit and miss depending on the individual office. And one of the problems that we saw was that our individual offices, because of some of the other issues they're dealing with, like caseloads and turnover, didn't have the capacity to probably be as proactive in recruiting for those and to be able to help supervise those. So by focusing in our administrative office of giving those offices better support so that they can have a more proactive and more robust internship program, that's definitely helped. And then we've already seen benefits from that. We've already hired some of those interns from last summer.
I guess I'm not getting the connection. If you have them in the two most populated areas of the state for those internships, how are we going to be addressing the legal deserts in our more rural communities?
So that's a good question. The reason we have those populated in those two most populated, or two of those more populated areas, was honestly because of space and capacity to actually house. We had more room in those offices to be able to do it there. Our goal, and one of our smaller requests, like in our fiscal year 2024 budget, is for some additional lease space for some of our offices that are currently landlocked, for current employees, but we could also use some of that space to be able to embed more interns in those offices. The other thing is that when we talk to those individuals about where they might want to go, if they are interested in coming back and trying to encourage them to do so, we've talked to them about, would you be willing to go to one of these other areas, one of these other offices, and trying to match them with where they're interested in practicing, and some of them are interested in rural practice, with the offices where we have positions. The issues that we have right now is that because of the cycle of law school hiring, we're to a point where we're starting to run out of vacant positions to hire for, and we're going to potentially miss out on a cycle of hiring if we fill those positions before we are able to get additional positions to fill. So even like, for instance, our positions that we're asking for fiscal year 2024 is significant. It's half of that 262 positions that we think we need. So we asked for 131 positions. Even if we only got a portion of that, that would still help with our ability to still participate actively in the law school hiring season, as it were.
Thank you, Madam Chair. I think that there might be some partnerships with, as far as housing, when you think of our 19 community colleges, most of which do have dorms. We think of our Regents institutions. So when are those dorms not full in the summer? Mm-hmm. When is there space available? Mm-hmm. I think that there's space there, and I think partnerships within our state structure is already there. They just need to be formed. Mm-hmm. Thank you, Madam Chair.
Thank you. It's an innovative idea to hopefully address some of these concerns in the more rural parts of our state. Committee, other questions? Yes, Senator Gossage.
Thank you, Madam Chair. Just a couple of quick questions. Heather, thank you for being here. A couple of notes that I took. 85% of all adult felonies are in Kansas require an appointed counsel.
Yes,
that's a lot.
That statistic from the Kansas Sentencing Commission, just to make sure.
Wow. Mm-hmm. And then I see that you said in 2019 you lost 25% of the attorneys. Is that correct? Because it seems like there's a large number of staff compared to the number of attorneys.
There is, and that's partially because there's an awful lot of staff work that goes into working cases that doesn't necessarily have to be done by attorneys. The attorneys themselves obviously make a difference as to how many cases we can technically handle, but I would much rather pay attorneys to do the attorney work and pay the staff to do the stuff that the attorneys don't have to be able to do.
So in my question then, is the 25% all of the staff, all of the employees, or is it just the attorneys that you've lost 25% of?
The statistics from 2019 about losing 1 in 4 was specific to the public defenders. The statistics for last year for the 20%. 1 in 5 was specific for the public defenders. Our staff turnover rate was 7% lower than that. I can't remember off the top of my head what the staff turnover rate, but it was significantly lower. Okay. And then since we've been able to fill the positions, since our implementation of our new pay structure last July, the vacancy rate for the positions that we have either still currently being advertised for or not committed to already, it was around 7% when we did our legislative budget update in December.
Thank you. And then I had a question in your testimony on page 3 that you were mentioning. Could you talk to us about the difference in having, you said Cherokee, Labette, and Crawford counties are asking to open a defender office. Yeah. Can you tell me what would be the benefit to that and the cost of that?
In that jurisdiction specifically, that's the 11th Judicial District, so it makes up Labette, Cherokee, and Crawford counties. We were approached by the judges in that jurisdiction over a year ago to look at whether or not it would be feasible to open a public defender's office there, because they've had such a reduction in the number of attorneys locally who are even practicing, and the number of attorneys that are still there practicing just cannot handle the volume of cases. We have a public defender's office in Chanute and a satellite office in Independence, but the distance of those offices from that area makes it very difficult, and with our staffing there, makes it very difficult to be able to cover the volume of cases in the 11th Judicial District. And so we did go through the process of collecting data and looking at what it would mean to be able to essentially cover cases there without having to ask, attorneys from Kansas City to drive down the 2 hours, to get down there one way. And decided that it made sense based on the caseloads and the amount that we're going to be paying our assigned counsel otherwise to make that trip, to go ahead and look at opening an office there. So our budget request this year includes funding to open an office in that region with a sufficient number of attorneys and a sufficient number of staff to help handle that caseload in that area. And the benefit to having that particular office is in that area is that if we do, for instance, end up with a significant case that has multiple co-defendants or something like that in Independence or Chanute, where you don't have to make that trip all the time, but something comes up where we need some conflicts counsel, they would be available for that sort of thing too. So it would be mostly for the 11th Judicial District, but it would be available if there were unique circumstances.
Thank you. And I would just add, Madam Chair, I recall when I served on the board, it seems like every one of our meetings were, how are we going to do this? How are we going to pay people? How are we going to get people to these places? We don't have enough attorneys. So I'm pleased to see that that has gotten a little better.
Yeah, I think this is a good example with our pay scale that we were able to implement, of where the investment in public defense has really paid off, in the sense that we're now able to better recruit for some of these vacant positions. Our turnover rate has gone down. I mean, I think it's going to take us time to build the new people that we're hiring up to a level where they're experienced enough to handle the same cases that some of the people who left were handling. But I think that's one of the reasons why keeping that progress moving forward is so important.
And then my last question, Madam Chair, is regarding recidivism. So, of course, if you've got 85% of these cases are coming to you guys, how many of these cases are repeat cases? Do you know?
I don't have that figure off the top of my head. I can probably guesstimate, and I would say it's a guesstimate. There is always a large portion of our cases that actually, not quite recidivist, but they're like probation violations. So people who are being monitored and then violate and they have to come back into the system for dirty UAs or that sort of thing. Every once in a while, it's a new crime, although the percentage of new crimes is fairly small compared to the more technical violations that come through. So there is a significant portion of those that are felony cases, but they are sort of that probation violation kind of level of case, as opposed to like a straight up, first time through trial on a murder, that sort of thing.
So perhaps that could be added to one of your potential solutions, would be, let's address that. Right? Because if we could reduce that, we could reduce the number of cases and reduce the number of defenders that you need.
I would be very interested in having conversations with prosecutors about how we could better handle those sorts of things. I mean, it is, that kind of goes back to some of the charging decisions that are made and some of the, the decisions about whether or not to do diversion versus probation. I mean, there's an awful lot of discretion there that, we can certainly have opinions on, but don't necessarily have a lot of influence on. But I'm certainly always open to having conversations with anyone who's willing to.
Thank you, Heather, and thank you, Madam Chair.
Thank you. Do those kinds of conversations occur between, we're talking about both sides of the V and the verses in the case, between the defense and the prosecutor? Is that an ongoing conversation, or is it
It depends jurisdiction to jurisdiction. I will say that one of the jurisdictions that we probably spent the most time with the prosecutors talking about some of these issues on is actually in Sedgwick County, because with Mark Bennett's office, because the volume of cases that is there and the impact we have. For example, we have a public defender's office in Wichita, a conflicts public defender, a contractor, and then a panel. And all of those have been exhausted for various reasons in Wichita. And so we've spent an awful lot of time talking with Mark Bennett's office about ways that we can try to work through these issues. And you know, we've definitely had some successes there, and we're still working on others. But I think, you know, jurisdiction to jurisdiction, it just kind of depends.
I'm glad to hear those conversations are occurring, and maybe this could be opening the door for more of those kinds of conversations so we can keep the wheels of justice rolling. I know that's kind of a cliche, but we do need to be addressing that always. And we heard in this committee of a backlog because we didn't have jury trials for a while, and we had an update on the state of the judiciary from the Chief Justice's office, and heard that those are kind of getting processed through. So it's a system of justice that needs to keep working and work properly. So thank you for your presentation today. And last call for any questions from any of the committee members. Seeing Senator Stephan.
Thank you. You know, maybe more of a comment than a question. You know, from listening to this, it's very clear to me that public defense is cornerstone of our legal system. And where we pay for law schools and we pay for public defense, it certainly seems like the opportunity to create some incentive within the law schools to have positions earmarked towards public defense, and even create a program that brings these kids out, young adults out, ready to go to work, where they don't really come out ready to go to work at this point in time. I would think that would be a very achievable objective.
Yeah. And I very much appreciate that, Senator. There are some of those things in place at our local law schools. There's a Polly Wilson Defender Project at KU School of Law. There's some clinics at Washburn as well, like their Third Year Anywhere program that we could potentially take an advantage of. Some of the, I think, issues there are capacity. So I think there are some beginnings of that there. I think the question is, where can we maybe try to expand the capacity so that we are graduating a higher percentage of people who are both interested in doing criminal defense and who are able to go through that system. So I think there's the beginnings of that. It's just maybe seeing where we can enhance it.
Well, thank you again very much for the very informative presentation and the answers to the questions. And it sounds like it needs to be an ongoing conversation and find some of these ways that these solutions can be brought forward and enacted. So,
well, thank you very much for having me today. And certainly if there are other questions, I'm more than happy to follow up with anything if you think of other things.
Absolutely. And I don't necessarily mean enacted by the legislature, but through conversations with stakeholders that you're having. So including possibly the legislature. So thank you very much for the thoughtful and thorough presentation. And with that, committee, then our business is concluded and we are adjourned.